powers, functions, and duties of the trustees and beneficiaries. First of all, we will see the appointment of trustees. In terms of section 10 of the trust ordinance, no one is bound to accept trust. This is an option to decide to accept or disclaims it. If you accept it, it can be acceptable by words or by actions. Whatever it is, it should be indicated with a reasonable certainty of such acceptance. Once accepted, a trustee who accepted the trust, then he can't renounce it. Then what he should do is, he must follow the procedure. In terms of section 48 of the trust ordinance, trustee who accepted trust cannot renounce it except with the permission of the court, first place. And second thing is, with the consent of the beneficiaries who are competent to contract. That means all the beneficiaries attain the age of 18, then they are competent to contract. In those situations, all the beneficiaries get together and decide that they can give the consent to discharge. Finally, by virtue of the power provided in the deed of trust. That's why I again and again I emphasized on that point. When you draft deed of trust, you must be very clear about these things. Whether we have provided for this situation. That's why here, by virtue of the power provided in the deed of trust. If there's a general power or general clause empowers the trustee to be discharged such a way or whatever, then that can be done without applying to the court. Then in that case, we will see section 73, trustee may be discharged. First, by the extinction of trust. That means there is no trust is over. Or by the completion of duties of the trustee. The trustee's duties over. That's clear. As may be prescribed by deed of trust. That's why the first 48 also we have seen, by virtue of the power prescribed by the deed of trust. Here also more or less similar section, as may be provided by the deed of trust. The fourth one, the appointment of new trustee in his place. Then he must be discharged. Then the consent of himself and beneficiaries, as we have seen in section 48, they must be competent to contract. That means they all attain the age of 80. Finally by court. In 48, section 48A, with the consent, with the permission of the court, here also by court. Then how it can be done? Then what's the procedure to do it? That's section 74. 74 provides the procedure to be discharged. Then every trustee may apply to the court by way of petition with the sufficient reasons for discharge. Now how can we identify whether he has sufficient reason? That's the court decision. If the court satisfies that there's a sufficient reason, then the court will discharge. But if you suppose there is no sufficient reason, then what to do? That's a problem. Because if there is no sufficient reasons, then the court will not discharge that person until otherwise there's a person accepts such trust. Then there must be another proper person to act as a trustee in his place. Then only the court will discharge that person. Another section we must see in relation to the dismissal. This is appointment or discharge. The dismissal. under section 72 of the trust order, then beneficiary has a right. Beneficiary has a right to require the trust property should be protected and administrated by proper person and by proper number of such person. Proper person is one thing and proper number is another matter. Then in that case, if the person is not fit, not capable of working properly, then the beneficiary can apply to the court. Beneficiary can apply to the court and ask to nominate to appoint another person. Then in that case, the court will dismiss the person, trustee already there, and appoint another one. Then here under 74, trustee make an application to follow the process. He must apply to the court by petition. The dismissal, another beneficiary will apply because the property should be protected properly and administrated properly. Then the beneficiary applies. Under 48, trustee must go because with the permission of the court, or if he wants to be discharged, then he must go to the under section 48 also. Trustee must apply. Trustee must initiate that case. Here in 73 also, trustee must do it. If the extension or the completion, there is no problem, that person will be discharged. In other cases, in the by court in the sense, then he must initiate the case. Then we will move in other section, that is 73. Yes, 73 already we have seen, that's a procedure. Beneficiary may apply. Then section 75. Where a trustee disclaims, or the trustee dies, or is absent from Sri Lanka for continuous period, in those circumstances, if the court is an opinion that the post or the office of the trustee should be declared as vacant, then the court will do it. The one thing. Then the other one is if the trustee is declared as insolvent, or the trustee desires to be discharged, or trustee refuses, or the trustee is unfit or incapable to act, then the court will decide in that case he is not fit person, he is not capable of acting properly. In that case, the court will deciding only those factors. The first one we have seen, the court declared that the office of the trustee is vacant, that's all. The second issue that we have seen here, the court will see that and declare that this person is not proper person. The trustee is not proper person, or trustee is unfit and incapable to act. Other one is trustee accepts another trust which is inconsistent to this trust. Then in those circumstances, court will not appoint. It should be the person who is nominated by deed of trust. Nominated by deed of trust, appoint the trustee. Suppose there is no person nominated to appoint a trustee, then what should be done? Then it should go to the author of the trust. Then in those circumstances, the author of the trust can appoint another new trustee. But if that person also not there, that's a long procedure, long list there. The third one is continuing trustees. If first place there is no one is nominated under deed of trust to appoint a trustee, then that's first one. And author of the trust, he says suppose he died, then that also gone. The continuing trustees, they can appoint another one. If suppose that also not properly done or something, there's a problem that cannot be done, then go to other one, last surviving and continuing trustee. Surviving in the sense, if he died last surviving, then the legal representative of last surviving and continuing trustee. Then the in other cases, retiring, the person going out of the picture, then the retiring trustee may appoint. In that case, there is a consent of the court is necessary. Then the court, then in the case where the last, the retiring trustee appoints a trustee, then there's a court consent is essential. Or otherwise, last surviving or retiring trustee, in that case also, he must get the consent of the court. Then this should be executed notarially, because if it is in relation to the immovable property, that should be done as per registration of documents ordinance, as like a deed or something, that should be executed. Then we will come to the section 76. 76 is another way. Now the thing is, under 75 there is a mechanism given to appoint without going to the court. The person nominated for that purpose can appoint, or author of that. All these persons listed, but it fails. It is found not practicable to appoint the trustee under section 75. Then the beneficiary apply by petition to the court for appointment of trustees. Then that should be done by beneficiary. Now we will come to the other part, 101 subsection 1G. That is in relation to the charitable trust, not anything else, not the private trust. In the case of charitable trust, if there is a breach of trust or it is required direction of the court for the administration of trust, then the AG, the Attorney General, or two or more persons having obtained the consent of the Attorney General may apply to the court to remove a trustee and, if necessary, appoint the new trustee. That is under 101(1)(g). This is only for charitable purpose, that also not beneficiary. In a way that is beneficiary, but here we say that interested persons. Then we will see 102. Section 102, that's in relation to the religious trust. That also is specifically other than the Christian religious trust. Then the religious trust other than the Christian trust, 5 or more persons, that we have seen in the charitable trust, 5 or more persons, that's interested person, that the definition also we have seen under charitable trust. Then 5 or more persons, after following the procedure given in section 102 of the trust ordinance. There is an administrative procedure to be followed. That's a mandatory procedure that should be followed. After that, following that one, the 5 or more person, after following this one, may apply to court to obtain a decree or order directing the removal of trustee and appointment of new trustee. Now, this is also appointment and removal, but this is only in relation to the religious other than Christian trust. That is the end of appointment, termination, dismissal of trustees. Thank you for watching this video.